Supreme Court issued Emergency Compliance Order May 25, 2026, giving all 50 states 30-day deadline to fully comply with recent gun rights rulings or face federal contempt citations, enforcement actions, and direct federal intervention. This final warning changes enforcement landscape nationwide because states defying Supreme Court gun rights decisions now face unprecedented federal consequences, including removal of state officials, federal receivership of state agencies, and criminal prosecution of governors and attorneys general who continue violating Second Amendment after June 25th deadline. In shocking 7-2 decision, Supreme Court held states willfully defying Bruen, carry rights rulings, permit elimination decisions, and assault weapon ban invalidations are engaging in constitutional insurrection, requiring immediate federal remedy. Chief Justice Roberts: we have been patient as states explored every avenue to evade our Second Amendment jurisprudence. That patience has expired. States have 30 days to bring all laws, regulations, and enforcement practices into full compliance or face federal enforcement, including removal of non-compliant officials and federal administration of state firearms licensing systems. Subscribe because understanding Supreme Court's final warning, which states face federal enforcement, what compliance deadline means, and how to document state violations before June 25th determines whether you protect your Second Amendment rights. Since Bruen, 2022, Supreme Court issued series of gun rights decisions: elimination of May issue carry permits, invalidation of assault weapon bans, striking down magazine limits, prohibition of purchase permits, ending registration requirements. Yet 15 blue states responded by enacting new restrictions to circumvent rulings. Sensitive places laws making 90% of public areas gun-free. Good moral character requirements. Mandatory liability insurance. Training requirements exceeding 40 hours. Application fees exceeding $1,000. Processing delays extending 18+ months. Rather than wait for individual challenges, Supreme Court issued Consolidated Compliance Order applicable to all 50 states. Let me break down what court ordered, which states face enforcement, compliance deadline requirements, penalties for non-compliance, and what gun owners must do. Number 1. What Supreme Court ordered. Core mandate. All states must immediately cease enforcement of any law, regulation, or practice inconsistent with Supreme Court gun rights decisions. Specifically, 1. Cannot require permits, licenses, or government approval before purchasing, owning, or carrying firearms. 2. Cannot ban firearms in common use including AR-15, AK-47, semi-automatic pistols, standard capacity magazines. 3. Cannot impose training requirements, fees, or delays beyond instant NICS background check. 4. Cannot restrict carry in broad, sensitive places, only genuinely sensitive locations like schools and courthouses. 5. Cannot require registration or government databases. Chief Justice Roberts, Thomas, Alito, Gorsuch, Kavanaugh, Barrett, Jackson joining. For 4 years since Bruen, certain states engaged in calculated defiance of this court's Second Amendment jurisprudence. When we struck down May issue carry permits, states enacted good moral character requirements functionally identical. When we invalidated assault weapon bans, states redefined assault weapons to include same firearms under new labels. When we prohibited purchase permits, states imposed training mandates and fees, making permits unavailable in practice. This pattern of evasion must end. Under Supremacy Clause, Constitution is supreme law. State officials take oath to support Constitution, not evade it. We order, within 30 days, all states shall 1. Repeal or amend non-compliant laws. 2. Cease enforcement. 3. Issue written compliance reports to this court. 4. Establish procedures for gun owners to seek immediate federal court relief. Failure results in contempt citations, federal monitors, removal of officials, criminal referrals to DOJ. Why 7-2 with Jackson? Jackson's concurrence emphasized that while she disagrees with court's Second Amendment interpretations, rule of law requires states to comply regardless of disagreement. Resistance threatens constitutional order. Dissenters, Sotomayor, Kagan, argued compliance order exceeds court's authority. 30-day deadline. Order issued May 25, 2026. States have until June 25, 2026 to amend laws, cease enforcement, Submit compliance reports. Number 2. Which 15 states face federal enforcement? Tier 1. Severe non-compliance. California, New York, New Jersey, Illinois, Hawaii. Comprehensive resistance, including sensitive places covering 90% plus of public areas, good moral character requirements, mandatory insurance, extreme training, 40 plus hours, application fees, $500 to $1,000 plus, processing delays, 12 to 18 months, continuing assault weapon bans, magazine limits. California example. AB 2847 requires $750 liability insurance, 40-hour training, $800 to $1,200, 4 character references with interviews, psychological evaluation, $400, 6-month minimum processing, sensitive places including all public transit, parks, beaches, government property, private property without posted permission. Total, $2,000 plus costs, 40 plus hours, 6 plus months delay. New York example. CCIA creates sensitive places including Times Square, all public transportation, places of worship, private property without explicit permission, all parks. Requires $400 fee, 18-hour training, $500 to $700, 4 character references, social media review, in-person interview, good moral character determination, 8 to 12-month processing. Tier 2. Moderate non-compliance. Massachusetts, Maryland, Connecticut, Delaware, Rhode Island, Oregon, Washington. Training 16 to 24 hours, fees $200 to $400, delays 3 to 6 months, sensitive places covering 40 to 60% of public areas. Tier 3, minor non-compliance, Vermont, Minnesota, New Mexico, Colorado, Michigan. Some restrictions potentially inconsistent but correctable through administrative changes. 31 states in full compliance: Texas, Florida, Tennessee, Georgia, Arizona, Indiana, Ohio, Missouri, Oklahoma, Kansas, Kentucky, Alabama, Mississippi, Louisiana, Arkansas, South Carolina, North Carolina, West Virginia, Montana, Wyoming, Idaho, Utah, Alaska, North Dakota, South Dakota, Nebraska, Iowa, Wisconsin, Pennsylvania, Virginia, New Hampshire, Maine. No permit requirements, no bans, constitutional carry. Number 3. Penalties and what compliance means for gun owners. Penalties after June 25th. Contempt of court, $100,000 per day fines. Federal monitors overseeing state licensing systems, reviewing denials, overriding improper rejections. Removal of governors, attorneys general, licensing officials who continue violations. Criminal prosecution under 18 U.S.C. Section 242, deprivation of rights under color of law, up to 10 years prison. Federal receivership placing state firearms agencies under federal control. Precedent: 1950s to 1960s civil rights enforcement, where federal government removed state officials, deployed federal marshals, placed state agencies under federal control to enforce desegregation and voting rights. Immediate rights restoration. Starting June 25th, any state law inconsistent with Supreme Court rulings is void and unenforceable. Gun owners in non-compliant states can immediately exercise rights. If state refuses to process firearm purchase, file federal lawsuit seeking immediate injunctive relief and damages. How to document violations. 1. Attempt to purchase fire AR-M or obtain carry permit under constitutional standard. No training requirements. No fees beyond reasonable processing, no subjective denials. 2. When state denies or imposes unconstitutional requirements, document everything: written denial, record conversations, save correspondence. 3. File federal civil rights lawsuit under 42 U.S.C. Section 1983, seeking preliminary injunction, permanent injunction, damages, attorney's fees. 4. Notify Supreme Court compliance monitoring. Email protected. Damages available. Under Section 1983, sue state officials personally for violating clearly established rights. After June 25th, Second Amendment rights clearly established by compliance order. Officials who deny rights face personal liability, compensatory damages, lost opportunity, emotional distress, punitive damages, to punish willful violations. Attorney's fees. State pays your legal costs. Potential awards. $10,000 to $100,000 plus dollars, depending on severity. Class actions. FPC, GOA, SAF, preparing class actions against Tier 1 states for systematic violations. If denied gun rights in California, New York, New Jersey, Illinois, Hawaii, contact these organizations to join class actions seeking billions in damages. Number 4. What gun owners must do before and after June 25th. Before June 25th. Preparation. 1. Document current denials. If previously denied firearm purchase, carry permit, or registration, gather all documentation. Past violations may be actionable after June 25th. 2. Join gun rights organizations, FPC, GOA, SAF, providing free legal support. $25 to $50 per year membership gets access to attorneys, legal templates, lawsuit guidance. 3. Prepare to exercise rights. Research firearms you want. Identify FFLs. Save money for purchases. After June 25th, enforcement. 4. Attempt to exercise rights. Go to FFL. Attempt to purchase previously banned firearm. AR-15, standard magazines. If state imposes training, fees, or delays beyond instant NICS, proceed. 5. Document violation. Get written denial or delay explanation. Ask, what law requires this training? What Supreme Court decision supports this fee? Record responses. 6. File federal lawsuit. Use legal templates from gun rights organizations. File in federal district court seeking preliminary and permanent injunctions. Federal judges bound by compliance order will grant relief quickly. 7. Report to Supreme Court. Email protected with details. Name, state, specific violation, documentation, federal lawsuit case number. 8. Seek damages. Demand damages for violation of clearly established rights. After compliance order, every denial is willful violation justifying significant damages and attorney's fees. Bottom line, Supreme Court issued final warning. May 25, 2026, giving all 50 states 30-day deadline to comply with gun rights decisions. Core mandate. States cannot require permits, licenses, or approval before purchasing, owning, or carrying firearms. Cannot ban firearms in common use. AR-15, AK-47, semi-automatic pistols, standard magazines. Cannot impose training requirements, fees, or delays beyond instant NICS. Cannot restrict carry in broad, sensitive places. Only genuinely sensitive locations permitted. Cannot require registration or government databases. Why 7-2? Conservative majority plus Justice Jackson ordering compliance. Jackson's concurrence. Rule of law requires states to comply regardless of disagreement. Dissenters argued order exceeds court's authority, which states face enforcement. Tier 1, severe non-compliance, CA, NY, NJ, IL, HI. Tier 2, moderate, MA, MD, CT, DE, RI, OR, WA. Tier 3, minor, VT, MN, NM, CO, MI. 31 states already in full compliance. Penalties after June 25th. Contempt of court, $100,000 per day fines. Federal monitors overseeing licensing. Removal of non-compliant governors, attorneys general. Criminal prosecution, 10 years prison for civil rights violations. Federal receivership of state agencies, gun owners. Before June 25th, document current denials. Join gun rights organizations. Prepare to exercise rights. After June 25th, attempt to exercise rights. Document violations. File federal lawsuits seeking injunctions and damages. Report violations to Supreme Court monitoring system. Seek compensation for willful rights violations. Subscribe because Supreme Court's final warning to states creates unprecedented enforcement opportunity and understanding compliance deadline. Documentation requirements and federal lawsuit procedures determines whether you exercise restored Second Amendment rights. Supreme Court sends final warning. 30 days until federal enforcement of gun rights in all 50 states.